So I'd like to introduce our second speaker, the speaker for today. Dr. Henry Mutai is a longtime friend of CIPIT. So without further ado, I'll invite Dr. Mutai to present.
I am indeed honored to be considered for this Open Air Distinguished Speaker Series, and I hope that in the 40-45 minutes that follows, I shall be able to share some thoughts on this particular topic that I've chosen that will be of use to you with regard to intellectual property rights. So the topic that I've chosen, as you can see, relates to IP rights promotion and protection under the tripartite free trade area, proposals for an intellectual property protocol. And I chose this particular topic because it is actually at the intersection of two of my passions, that is regional integration and intellectual property. To start off with, you may know that last year, the agreement establishing a tripartite free trade area was signed in Cairo, Sharm el-Sheikh actually, bringing together member states of three regional groupings, that is COMESA, the East African Community, and the Southern African Development Community. And the aims of this agreement are to try and resolve some of the issues that currently prevail regarding overlapping regional arrangements and promotion of free trade among African countries. So specifically, it's aimed at promoting economic and social development, the creation of a large single market, and enhancing of regional and continental integration. So what was signed last year actually marked the end of phase one of the negotiations, which was to do with free movement of goods. And even though the agreement has been signed, it's not yet completely in effect because there are certain outstanding issues. But for our purposes here, in phase two of the negotiations, which are now underway, 5 different topics are to be covered. That is trade and services, cooperation in trade and development, competition policy, intellectual property rights, and cross-border investment. So the focus of this particular talk is going to be intellectual property rights and how this particular issue can be covered by the participating states that have negotiated the tripartite free trade area. This is likely to be quite a complex task for a number of reasons, some of which I've highlighted here. As you may know, intellectual property currently is the subject of quite a number of debates regarding the best route, the best framework that can be put in place. So with regard to intellectual property and development, there are developing countries that argue that they are not in a position to put in place very stringent IP frameworks because they need the flexibility to enhance their development for developmental purposes. You also have the issue of the territorial nature of intellectual property, which means that every country retains the flexibility to tailor their IP framework to their domestic environment. You have issues regarding intellectual property and access to medicines when it comes to patent law. Climate change and green technology is also coming up to be a very hot topic. There's the issue of balancing between rights and exceptions with regard to all the different branches of IP, taking it that you at least have a basic idea of which the main forms of IP are. So I'm not going to be going through what copyright, trademark, patent law, etc. But in all those forms, you know that the owner is given certain rights, but those are subject to certain exceptions for purposes of the public good. And then, of course, there's the issue of traditional knowledge, genetic resources, and traditional cultural expressions. Here in Kenya, we had the Traditional Knowledge and Cultural Expressions Bill being signed into law last month, I believe, which is setting in place the newest IP framework, and we wait to see how that goes. But with all these issues, and you've got all these countries that are participating in the tripartite free trade area negotiations, you can see that there is a lot of latitude for disagreement and debate as to which is the best framework. So, in looking at this particular issue, one of the first questions that I asked myself is, what would be the objectives of a protocol? Because in the negotiating guidelines or instructions that were given by the heads of state, the negotiators are supposed to come up with a protocol of some sort that will cater for intellectual property. So there could be various forms that this protocol could take. They could opt for procedural harmonization, that is to say, the partner states could say, let us put in place one harmonized procedure for processing and granting rights. They could opt for substantive law harmonization. So what substantive rights, what exceptions will be put in place with regard to the different IP rights. Another alternative would be to talk in terms of non-binding best endeavors cooperation. This would probably be put in place where agreement on substantive law proves to be unattainable. Or lastly, you could have a combination of all the above. So there's really a wide range of possibilities that are open to the negotiators in terms of handling this particular issue. In addressing this issue, I thought, okay, much as we have got these three African blocs carrying out their negotiations, this is done within an international context where almost all these states are partners or are part of a specific international agreement. So I asked myself, okay, so what is taking place internationally? And if you look at the international context, you have three main areas or three main players that I figure are relevant. You've got the WTO, the World Trade Organization, which is primarily focused on trade, but since the end of the Uruguay round, has also delved into intellectual property, primarily through the Agreement on Trade-Related Intellectual Property Rights. You've also got WIPO, which is the World Intellectual Property Organization, and this provides a forum to develop a balanced global IP system, as well as providing certain IP services to members. And lastly, you've got the African Regional Intellectual Property Organization, which provides a forum for member states to discuss IP issues, as well as providing some services to member states. If you look at more closely at TRIPS, then I'm not sure if you will have read or discussed it closely, but what TRIPS did, the type of framework that they opted for, was to refer members to a certain number of the main IP treaties and incorporate them into the WTO. So whether or not you're a member of those particular treaties, if you're a member of the WTO, then you're obliged to comply and adhere to certain provisions. So Article 2 brings in the Paris Convention. Article 9.1 brings in the Berne Convention. Articles 3.1 and 14.6 bring in the Rome Convention. And Article 35 brings in the treaty integrated circuits. The states that are participating in the tripartite negotiations, we've got 26 countries that make up the EAC, COMESA, and the WTO. Of those, all 26 are members of WIPO, so that provides basic framework. Then, of the 26, if you look at the WTO, you have only 21 members being members of the WTO. 4 are observers, that is Sudan, Libya, Comoros, and Ethiopia. And then you have Eritrea, which is not a member of the WTO, and it is not an observer. So those 5 countries are not bound by TRIPS. If you look at the Berne Convention, Then 21 countries out of the 26 are members of the Berne Convention. Surprisingly enough, Uganda is not a member of or party to Berne. And then 24 of the 26 are parties to the Paris Convention. Eritrea and Ethiopia are not. If you turn to the Rome Convention, only one of the 26 is a party to the Rome Convention, that is Lesotho. So just at that stage, you can see that there are certain gaps within the coverage of those main international treaties. And what that means is that, for example, Ethiopia, which is just our neighbor to the north, is a party to WIPO but has not signed Berne and it has not signed Paris Convention. That means that they do not enjoy any reciprocal IP rights with Kenya. If a Kenyan publisher or any Kenyan national wanted to print some Ethiopian work, Ethiopian authors will not be protected in Kenya under our IP laws because we do not share any membership of the main treaties, either Berne for copyright or Paris for industrial property. Then if we look at ARIPO, which is the African Regional Intellectual Property Organization, only 13 of the 26 are members of ARIPO, about 7 being observers. So again, ARIPO is not really in a position to provide a unified framework, even though it does serve quite a number of member states. And if you look at the Harare and Banjul protocols, you'll find that not all members of ARIPO have signed those particular instruments. What I did next is to ask myself, okay, if we have agreed as tripartite member states to address the issue of intellectual property, what have the member states of each of the 3 RECs actually done with regard to protecting IP so that we can see how much interest or how much activity has taken place in those blocks. If you look at the East African Community Treaty, intellectual property is mentioned only once in Article 103 on science and technology. So that tells you that when the original 3 partner states, that is Kenya, Tanzania, and Uganda, were drafting the treaty, intellectual property was only considered as an issue that relates to science and technology and the promotion through protection of IP rights. Then 5 years later, when the Customs Union Protocol was negotiated and concluded, there was only one reference to IP, and that was in Article 38 on interlinkages with other areas of cooperation. So the Customs Union Protocol simply refers to the treaty and says that the member states shall cooperate in that area. And most recently, we have the Common Market Protocol, which entered into force in 2010. And this now actually does go into a bit more detail with regard to intellectual property. So under the Common Market Protocol, IP is mentioned, first of all, in Article 5, Sub-Article 3, as one of the areas of cooperation. It is mentioned in Article 29 with regard to cross-border investments, where it is investments are defined as including intellectual property. And member states, of course, agree to protect investments. Then it's mentioned in Article 42 with regard to research and technical development. And lastly, it is mentioned in Article 43, which targets cooperation in intellectual property rights. And in Article 43, it's quite detailed in form. So it says, among other things, that the partner states undertake to cooperate in the following areas: copyright and related rights, patents, layout designs of integrated circuits, industrial designs, new plant varieties, geographical indications, trade and service marks, trade secrets, utility models, traditional knowledge, genetic resources, and traditional cultural expressions and folklore, as well as any other areas that may be determined by the partner states. And for all those areas, they agreed to put in place measures to prevent infringement, etc., and to cooperate in fighting piracy and counterfeit activities, amongst others. Lastly, one of the key provisions here is that it states that the Council shall issue directives for cooperation in the administration, management, and enforcement of IP rights, as well as the elimination of discriminatory practices in the administration of IP rights. Under the Customs Union Protocol, the idea was that the partner states would conclude a protocol on IP. In the Common Market Protocol, it seems that they decided to take a different direction and give the power to the Council, East African Community Council of Ministers, to issue directives. Needless to say, this has not been done, so much as the obligation exists in the treaties, it has not actually been operationalized. So that is the situation under the EAC. In COMESA, to which 4 of the 5 EAC member states belong, there is one provision on intellectual property that is in Article 159, which relates to investment, promotion, and protection. And as in the Common Market Protocol, investments are defined as including intellectual property. So member states are obliged to protect intellectual property as part of investment protection. And in the COMESA Customs Union regulations, Regulation 30 provides a linkage with other areas of cooperation, including intellectual property once again. And then lastly, one thing that is different about COMESA as opposed to the EAC is that COMESA has actually come up with an IP policy that covers a lot of the areas, the important areas, including IP and economic development, IP and trade, IP and cultural industries, IP and traditional knowledge and expressions of folklore, IP and information communication technology, IP audit and valuation, which is an area that is often overlooked, copyright and related rights, and industrial property. So we can see from this that COMESA has put in place or has developed a policy that hopefully will guide the development of more detailed and binding obligations. But once again, we can see that there are no binding obligations for COMESA member states. Then we have the third of the participating states, which is SADC. And SADC, in the SADC treaty, there is no reference at all to intellectual property. So at the stage where SADC member states were coming together, they were not concerned specifically with intellectual property and did not refer to it. Later on, when they negotiated and concluded a protocol on trade, they did include IP. First of all, in Article 9, under the general exception. So that provision states that member states can derogate from their free movement of goods obligations for purposes of protecting intellectual property. And secondly, in Article 25, there is a specific reference to intellectual property that imports the TRIPS obligations. So here, the protocol provides that member states shall adopt policies and implement measures within the community for the protection of intellectual property rights in accordance with the WTO TRIPS. So under this particular provision, you can see that SADC has specifically and explicitly quoted TRIPS obligations as far as IP rights are concerned. Now, this is different from what has taken place in the EAC and in COMESA, because as we saw in the previous 2 slides, neither the EAC nor COMESA actually set out any specific obligations that partner states must abide with. They just have these rather general obligations for cooperation. If we look at the wider picture at the African Union to see what might have happened at the continental level, in the Abuja Treaty that establishes the African Economic Community and which is taken as the blueprint of regional integration on the continent, there is one reference to intellectual property, which is in Article 35 on exceptions and safeguards. And as with SADC, it is providing that member states can derogate from their free movement obligations for purposes of protecting intellectual property rights. So once again, we can see that there is a big focus on intellectual property from a nationalistic point of view, that member states retain the discretion, retain the right to put in place IP frameworks that work best for them. And in promoting those IP or enforcing those IP rights, they can derogate from the free movement of goods and other freedoms under the agreement. One last category of agreements that I looked at to anticipate what direction member states can take is the EPA, the Economic Partnership Agreements. These have been in the news over the last 2 months very prominently. You have the EAC, which has negotiated and concluded an agreement with the EU regarding EPA rights, but when these were due to be signed a couple of months ago, Tanzania refused, and after some negotiations, Kenya and Rwanda eventually decided to sign without the participation of the other 3 EAC countries. So it is useful to look at what has been agreed in those agreements in order to see what obligations, if any, the partner states are taking, because again, these will have to be taken into consideration when negotiating a tripartite agreement, because you do not want to have conflicts between these different instruments. So in the Cotonou Agreement, which is what was prevailing before the EPAs came into force, and the Cotonou Agreement is between the European Union and the countries of the African, Caribbean, and Pacific region. Article 46 provided that parties recognize the need to ensure an adequate and effective level of protection for IP rights and agree on the need to accede to all relevant international conventions as referred to in Part 1 of TRIPS. So the signatories to the Cotonou Agreement all agreed that there was a need to protect IP rights, and as a baseline, the agreements that are referred to in Part 1 of TRIPS should be acceded to. When we now go to the negotiation of the EPAs, we've got EPAs that have been signed by each of the 3 blocks. So SADC has signed one. ESA has the Eastern and Southern African states have an interim agreement, and of course we have the EAC-EU EPA. And in the EAC-EU EPA, got 4 provisions that refer to intellectual property. First of all, in Article 3, it is provided that negotiations on IP shall be concluded within 5 years of the entry into force of the EPA. So as for now, there are no substantive provisions, but the parties have given themselves 5 years to negotiate and come up with substantive agreements. Article 74 and 83, which deal with agriculture, contain specific obligations regarding geographical indications. And here, again, it's a matter of promoting GIs and recognizing their importance in terms of value addition. So you may know that in the EU, the issue of GIs is considered as very important, and there are very stringent rules that they have come up with and that they try and promote around the world. And lastly, in Article 28, you've got a general exceptions clause, which allows measures necessary for protection of IP and the prevention of deceptive practices. So that is as far as the EAC-EU EPA is concerned. So as of now, African countries or East African community countries have not been forced to sign on to any stringent IP obligations. With regard to the ESA EU interim EPA, ESA here is Eastern and Southern African states, of which 4 of them signed because of the issue of overlap. So Mauritius, Madagascar, Seychelles, and Zimbabwe are the countries that are bound by this. And there you've got Article 35, which includes IP as an area of cooperation. Article 53, which is referred to as the Rendezvous Clause, which says that detailed negotiations are to take place at a later date. So unlike the EAC EPA, there is no time limit of 5 years, but that's partly because that is still an interim EPA at this stage. And lastly, in the Article 56, you've got a general exceptions clause, which is similar to that under the EAC EPA. Lastly, the SADC EU EPA. And here, there are quite a number of obligations which are a bit more detailed than in the previous 2. Article 46 states that the parties reaffirm their commitments under Article 46 of Cotonou Agreement, which you recall is the one that provides a baseline and states that they should sign up to the Part 1 TRIPS treaties. Secondly, the parties are to grant and ensure adequate, effective, and non-discriminatory protection of IP in line with international agreements. To consider entering into negotiations on protection of IP at a later date, but again, no specific timelines are given. But lastly, in Protocol 3 of the SADC EPA, there is a very detailed and comprehensive framework regarding the protection of geographical indications. But that particular framework only covers South Africa and the EU. If you're familiar with geographical indications, and especially when it comes to wines and spirits, South Africa has a very vibrant wine industry with very many different wineries around the country that try to promote their products by virtue of where they are produced. And likewise, in the EU countries, France, Italy, Spain, etc., all have very vibrant wine sectors, as well as other agricultural sectors that benefit from geographical indications. So Protocol 3 sets out detailed provisions regarding which indications are to be protected and how those are to be protected. And then any of the other SADC countries is free to sign on to that particular protocol, but there is no obligation to do so. So that already, if you're talking about a tripartite free trade area agreement, means that for GIs, given these obligations that South Africa has vis-a-vis the EU, it's unlikely that they will agree to anything that would undermine those obligations when it comes to a tripartite IP protocol. So, in conclusion, some of the questions that I pose and which we can discuss when it comes to Q&A is, given this wide variety of approaches that have been taken within the trade blocs, what angle should now be taken by the negotiators? Are we going to stick to seeing IP as a science and technology issue that is just concerned with the promotion of IP in sciences, so looking at building up universities, building up research capacity, putting in more money to those areas? Or are we going to look at it as an investment issue where IP is seen as an asset that companies have created and invested in and which needs to be protected? So in terms of things like counterfeiting or appropriation of IP rights, what is to be done to protect the investment that companies have undertaken? That could be important for pharmaceutical companies. Or just are we going to look at it simply as an issue of enhancing enforcement and protection of IP rights? So here we look at the partner states identifying certain minimum rights that need to be protected by member states, and then including them in a binding form in the protocol. Alternatively, then, what will the scope of cooperation be? As we have seen, if you look at the EAC Common Market Protocol, they set out a very long list of areas that are covered under IP. So should that long list be transferred to the IP protocol under the TFTA, or should it be restricted to maybe 3 or 4 of the main forms of IP? What about some of the emerging areas such as traditional knowledge and cultural expressions, where some of the partner states may have a strong interest? What will happen to those areas? In terms of minimum obligations, are we going to ask or require countries to sign up to the main IP treaties? Will they do so? So, for instance, in that table, Eritrea, apart from being a member of WIPO, has not signed any of the main IP treaties. Would this provide an opportunity for a country like Eritrea, a country like Ethiopia to sign? And will they sign, or are there other factors that play or that have prevented them from signing up to those treaties? Then the other issue that may arise in the negotiations is, are we going to see a replay of what happens at the international stage between developed versus developing countries, only that we'll see developing versus least developed countries taking different positions? We've already seen that happening here in the East African community with regard to the EPA, where Kenya, as a developing country, is the only country that would have missed out on market access to the European Union. And as a result, Kenya has ended up taking its own path and signing and ratifying that particular treaty. So when it comes to negotiating an IP protocol under the TFTA, will we have least developed countries asking for more flexibility, while the more developed countries or the developing countries with a stronger IP framework push for greater protection of IP rights? Then, related to that, are we going to go for a binding or a non-binding protocol? That is to say, are we going to have the sort of legal language that talks of shall do this and that, shall sign up to this and that treaty? Or will it be the best endeavors language of the member states agree to cooperate in this particular area? They agree to cooperate to fight counterfeits and piracy, which, when it comes to measurement of achievement, become very amorphous, and it's hard to pin down whether or not a country is actually living up to its obligations. Of course, the benefit of a non-binding agreement is that the member states retain their flexibility with regard to their domestic IP frameworks. And then another issue is institutional framework. We have got a RIPO already in existence and operating as an institutional framework for protection and promotion of IP rights amongst English-speaking countries. Will we get a separate IP framework under the TFTA, or can there be some sort of reference to a RIPO where we use a RIPO as the core that other member states can then sign up to and join, so that we build a RIPO as the core IP institution for this particular region, if not for the continent as a whole? So those are among the issues that I thought I would flag in this particular talk. And as you think about what I have discussed, these negotiations will not be over very quickly, much as there is a tight timeline that was put by the heads of state. Going by past practice, past history, these negotiations will take years. So there is a good chance that some of you here may have a chance to influence what comes out of it, whether through writing research articles or actually being a part of the policy-making team. And again, because these are progressive, what may be agreed immediately in the next 2 or 3 years is likely to just be a framework that can then be developed and built upon as the years pass by. There are opportunities here for IP to be promoted, but again, in doing so, are we going to be promoting a flexible, open form of IP, or are we going to be promoting a very rigid, owner-oriented IP framework? I think these are issues that the negotiators will need to consider very seriously in terms also of what they can actually accomplish domestically, because, again, the capacities of the 26 negotiating countries differ greatly from countries such as South Africa, Kenya, if I may say so, Egypt, which have a very developed IP framework and IP offices, to countries that may still be operating as part of maybe the Attorney General or the State Law Office, and with very limited capacity, both at government level and in the private sector. So I will end there. If you want to have a look at the entire paper, this was actually a paper I published a couple of months ago as a working paper for TRALAC, the Trade Law Center. If you go to the TRALAC website, you can have access to the entire paper, and that was published with the support of US aid, although, of course, all the views expressed therein are my own. So that brings me to the end of that particular presentation. Then, in 2 minutes, I want to also draw your attention to a different but related initiative. Some of you may have heard of the International Law Association, which is based in London and brings together branches from all over the world. And 2 months ago now, in August, we had the biannual conference of the International Law Association, where one of the committees that is a part of the Intellectual Property and Private International Law Committee presented a report, which is still in draft form, and sets out certain guidelines property in private international law that aim to guide states in resolving certain issues regarding civil and commercial matters that involve IP rights which are connected to more than one country. And what this initiative about is trying to get the main leading scholars in IP to come up with guidelines that can be applied by courts or used and referred to by practitioners when you have a dispute that concerns more than one state. So, for instance, you have something that is published on the internet in country A that affects country B and C. And maybe the person who's publishing it is in a different country. Who has jurisdiction over that? What sort of remedies can be put in place? So these guidelines, these draft guidelines, try to address some of those issues. They are open for comment at the moment. So if you go to the International Law Association website, you can download those, have a look, see what is being discussed, and see how they can relate to our IP framework here in Kenya. And possibly you may have some ideas that you would wish to share on that. So with those many remarks, I think I shall say thank you very much, and I look forward to answering any questions, comments that you have.
And I will ask the first question just to get things started. Who is driving the process of getting intellectual property into these treaties? Is there a specific country or a regional body or maybe a corporate entity? Who would you say is the leading driving force in that?
There's not really one specific country as far as the tripartite free trade area is concerned. It's more a matter of this view that if you have a trade agreement or a regional agreement, that intellectual property has to be addressed in some way, one form or the other, because intellectual property will affect the other issues that are being discussed, such as free movement of goods or free movement of services. And this goes back to TRIPS. So I guess it's borrowed from how the WTO is structured. So from that time on, it has come to be seen that at some stage you have to address intellectual property and see how that can be harmonized so as not to to obstruct free movement of goods. Yeah.
Thank you very much, Dr. Mutai. Who's going to be passing the mic? Oh.
About your conclusion, the last one, institutional framework, I have a suggestion, and especially with regards to the East African society, that if we had a synergized IP law for all the East African countries, and then we have maybe an institution with branches in all the countries that effected this IP law, then to this extent we are making progress. So that is my suggestion under the institutional framework.
It's an interesting one, and I think that as integration progresses amongst the East African community countries, it is something that will definitely have to be thought about very seriously. Because if you look at what happened in the EU, where you now have patents that cover the entire EU, you have trademarks that cover the entire EU, then we may go that direction, because when it comes to issues such as counterfeiting, unless you have a unified IP framework, then you can have one company owning a particular trademark. Say we use matches, because I don't know if you've covered Rhino matches in your IP course, but if you have one particular manufacturer of matches under the brand Rhino in Tanzania and another one under the brand Rhino in Kenya, which are substantially similar, then if you have free movement of goods, then those will freely cross borders of the two countries. But that will immediately lead to infringement of the other party's trademark. So what is to be done in that particular scenario? So scenarios such as those may lead us towards the creation of an East African community legal framework. But again, we do not need to reinvent the wheel. Already, ARIPO exists. Maybe the member states can look at giving ARIPO more powers to handle such issues, but that will now again infringe on the sovereignty and the IP frameworks that each of the countries already has. So it would be very difficult, but not impossible, because, as I said, the EU has already done it. So we may have to look at what lessons can be learned from what they did to make sure we do not make any mistakes that they made, and also to make sure that the framework that we come up with is one that serves our needs, not one that is just transplanted without any change from Europe.
I invite you to visit the website of Open Air. It's listed on the banner. And I hope to see you at our next speaker series event, which we hope to hold before the end of the year or possibly beginning of next year. Thank you and have a good afternoon.